Just okay, good evening, everyone. Welcome back to another session of our webinar. I think it's been some time since we had a webinar, mainly because I went for a diving trip to Japan. And then last week, my colleague couldn't make it for the last week's webinar. And since it's the third quarter of the year and everybody is more or less in the holiday mode, I'm also slowing down a little bit, not working. So we have back Mr. Dave Sundram. Dave is a friend of mine who has joined another friend of mine who is, oh my God, what's his name again?
Rama.
Yeah, Rama. And they are now partners there. Two young lawyers. And Dave was just telling us that see how important it is now, because the number of cases for medical legal cases against doctors is really escalating. I think it's also the awareness of patients, and somehow or other they are more educated these days and also more courageous. Okay. So because of the social media and the publication of the recent high-profile cases with a lot of money, I think a lot of people see benefit in pursuing this type of cases. Anyway, without further ado, we invite Dave. Dave, please tell us something about yourself. Sorry, my voice is I just got my voice back. Actually, I developed a laryngitis after coming back from Japan. Okay.
No worries. So my name is Dave Sundram. I'm a lawyer practicing at a firm called Ram Low, which specializes in medical legal matters. So for the last 10 years, I've been involved in various medical negligence cases, acting mostly for patients, but also on occasion for a doctor. And I've also appeared before the Malaysian Medical Council and Malaysian Dental Council, both for patients as well as practitioners. The topic of my that I'll be dealing with today is managing medical legal issues. This is really for directed at healthcare practitioners. So it's not going to be law heavy on the complexities of legal arguments, but more information that'll be useful for healthcare practitioners to know about medical legal issues and what they might have to be prepared for in the event they face a medical legal issue, or they are involved in some way in a medical legal issue in the future. So what I propose to do is I have some slides that I will share. If there are any questions, maybe you can type it in the chat. If the question is something that I will deal with later in the presentation, then I'll just mention that. So I will start sharing my slides now. Okay, so first I will cover what are the main types of medical legal issues that you might face. This list is not exhaustive, but most of the time doctors will be concerned about suits before the courts for negligence, that's civil suits. They will also be concerned with complaints to the Malaysian Medical Council for misconduct. And sometimes they would also be concerned about inquiries by either the private or government hospitals or by the Ministry of Health. Sometimes they may not necessarily be the subject of the inquiry, but they might be called to give an account of what had happened in regard to the care given to a particular patient. So some statistics that I have from the Ministry of Health Malaysia's annual report, this is from 2022. It is not, we don't have the latest statistics, but just in 2021, there was 247 reported medical legal complaints and litigation cases in Malaysia, average of 45 months for a medical malpractice suit from incident date to trial date. This is from the report of 2022. Now I think it's definitely longer than 45 months. After the backlogs caused by the pandemic, it's very commonplace for trials to get postponed. So it can take a while for these suits to reach a settlement or a judgment. So it can be much longer than 45 months that the practitioner may have a suit hanging over their heads to deal with. And RM 30 million total recorded compensation and settlement payouts in 2021. So over the course of this year, some of you may have noticed that there have been a number of online articles about several judgments this year, all of which the judgment sums are in the millions. So these kind of cases are on the rise, and it'll be something you want to be prepared for in the event you're involved. Whether or not the complaint is against you, you may also end up being either a witness or an expert in such cases. So examples of, incidents which can give rise to medical negligence, it's very simply put, a diagnosis that's negligent. I can give examples like, diagnosing a case of dengue as a common cold, discharging a patient in a situation where admission is warranted and called for, or, getting the severity of the condition wrong. Like, for example, finding that the cancer is stage 1 when it is in fact stage 4, or failure to diagnose something altogether. So for one example of that would be failure to recognize an ectopic pregnancy, perhaps in a case where there's a female patient complaining of severe abdominal pain. And then also, maybe diagnosing mumps or orchitis instead of testicular torsion. So these are the kind of incidents which can give rise to suits. When it comes to negligent treatment, that could be anything from, administering conservative treatment in an acute case where more urgent intervention is required, or, it can also involve the procedure itself being negligently carried out. So one common example that we usually give is inadvertent perforation at the base of the skull during a nasal procedure. So trying to take a specimen from the nasal cavity, but you perforate into the base of the skull, that can be an issue of negligence during the surgery itself, and negligent advice that speaks for itself. So that's potential issues that can give rise to a medical negligence suit. When it comes to complaints before the medical council, the medical council deals with something different. The medical council deals with infamous conduct in any professional respect. And regarding what is infamous conduct in a professional respect, the Malaysian Medical Council's Code of Professional Conduct has described it as sufficiently immoral or outrageous or disgraceful character. And it has also drawn a distinction between infamous conduct and negligence. It's not always the two will be there in one case. So there can be negligence, but no infamous conduct. There can also be infamous conduct with no negligence, and there can be situations where both of them are present. But the Code of Professional Conduct said that the council is not ordinarily concerned with errors in diagnosis and treatment, or with the kind of matters which give rise to an action in the civil courts for negligence, unless the practitioner's conduct in the case has involved such a disregard of the standard of care that he should have provided to his patients, or such a neglect of his professional duties as to raise a question of serious professional misconduct. So in a sense, standard negligence in and of itself may not necessarily be misconduct. This is something which lay people and patients often get confused with. So often people might come to me seeking advice, and they'll say that, look, why don't we go to the Malaysian Medical Council and get adverse finding against the doctor there, and then we can use that to support the court case. But the thing is that the medical council and the courts are looking at two different things. One is infamous conduct, the other is negligence. So just because there might be a strong case for negligence doesn't necessarily mean that there's also a strong case for infamous conduct. So that's something to bear in mind. But there can be cases of overlap which results in both a negligence suit and infamous conduct. One example is where, let's say there's an adverse outcome to the patient because of negligence, and healthcare practitioner lies about what had happened to cause the injury, and it's like a blatant lie. That can arguably amount to infamous conduct. So it's besides the negligence itself, the doctor's conduct in concealing it or lying about it may amount to misconduct for the MMC to take action. So
Can I ask you, for
yes.
example, let's say a doctor acts inappropriately, for example, with a woman, no chaperone, and the woman has complained of inappropriate, it could be inappropriate touching or you know, holding her breast. Now, can it be both?
So that example would be amount to misconduct. It will also amount to there'll be a criminal case as well. So if a patient is subject to that, probably their options would be to one, of course, to lodge a police report as soon as possible so that the police can take action on the criminal aspect of it. But also, if they want to, they can complain to the Malaysian Medical Council for the doctor having breached his ethical duties, doing it without a chaperone and inappropriate touching and all of that. It would
So,
also be.
but it cannot be sued under indemnity lah.
Okay, so for negligence, you sue for harm caused. So, but of course, when let's say there's inappropriate touching and whatnot, there can be psychological harm and whatnot. But so you could bring a case for negligence as well if you can show that there's harm caused. But uh,
No, the
it-
reason is because, for example, you complain to MMC, you make a police report, it's a criminal case, it's a civil case. You don't, the patient has will not be how you call that? Will not, even she wins, she doesn't win anything, no money. So how
right.
does she get compensated in that sense against a
Yes.
professional?
So that brings up an important point. The Malaysian Medical Council, like you mentioned, cannot award compensation. Only
That's
the
right.
courts can. So, in such a situation, if the patient is primarily concerned with getting monetary compensation,
Yeah.
then yes, her option would be to file a case before the courts. But in a case like what you mentioned, where it's
Yes.
inappropriate touching and all of that, in most of these cases, the patient would want to do exercise all of these options in tandem
Okay.
simultaneously.
Well, then, oh, I'm sorry, but I don't think there's anyone from the indemnity insurance that we can ask whether the indemnity insurance then will cover the doctor for this.
Yeah, that will depend greatly on the wording of the insurance contract, the indemnity contract. So if you look at some of the flyers from the indemnity providers now, it very specifically says they cover negligence. They even cover, defamatory statements, made in the course of the business. They even cover coverage for aggravated damages and things like that. So we'll have to look at, but you'll also have to look at the wording of the insurance contract to see if there's any exclusions. Because sometimes they say, okay, this is covered, but they might also say this does not cover, if you.
Yeah, I think it's not fair to cover, right? Because it is too personal and it's not appropriate in my
Yeah.
opinion. I mean, okay, we go on then.
Okay, so yeah, in those cases, a patient would likely exercise all three options. So, talking more specifically about complaints to the medical council, it's important to bear in mind that the standard of proof here is beyond reasonable doubt, which is a higher standard than civil cases for negligence. So, civil cases for negligence is on the standard of known as balance of probabilities, or in layman's terms, it's basically 51% and above. You prove if there's a 51% and above chance that the doctor is negligent, then the plaintiff will succeed in his case. Beyond reasonable doubt is a much higher standard. It's not defined like this in the law, but in sort of to simplify it in layman's terms, you can take it as say a 95% and above chance. So the standard to which you have to prove things is much higher, which also means that it can sometimes be more difficult to succeed in a complaint before the Malaysian Medical Council than it is in a civil case for negligence, depending on the facts.
But of
Now,
course, it's only natural that the name in itself is Malaysian Medical Council. They're chaired by doctors, so chances are they will also support their colleagues, right? Do you not think so?
I mean I mean that's possible, but it's difficult to say because sometimes also, you know, if the say all complaints are dismissed, then, you know, people will be questioning
No,
what's the medical
of
council
course.
doing.
But then you see these complaints, okay, when the patient complains to the Malaysian Medical Council, um, there is no monetary compensation. Okay, so it's all about characteristic of the doctor somehow or other, right? Do you?
Essentially, it's about getting the doctor in some trouble,
Yeah,
whether,
that's good. To
yeah.
get the doctor into some kind of trouble, because it's the judgment then become proof without reasonable doubt is fairly fair to me, lah.
Yeah. So, to bear in mind is what the MMC can do is that in the exercise of its disciplinary jurisdiction, it can impose various disciplinary punishments. So, some examples of what the MMC can do is the lightest is just issue a reprimand. So there's a formal reprimand, and then there's no other consequences for the practitioner. But besides that, they can order that the practitioner's registration be subjected to certain conditions, such as undergoing certain educational courses, or that the medical practitioner must report on his or her medical practice to such other practitioners as the council may specify. So the council may even impose a condition: in order for you to maintain your registration, you have to report on your practice to this doctor. They might assign a doctor. Or if it's in a larger hospital, you might have to report to a doctor above above you. So that's in terms of undergoing special education, that's also something that the medical council can do. A more stricter punishment is that they can order temporary suspension from the registrar. So that means the doctor would not be allowed to practice for a fixed period. And then, of course, they can also, on top of that, order that the name of the medical practitioner be struck off the register. But that is very, very rare, only for very, very serious uh, issues of misconduct. So that is not very commonly seen. And on top of that, they can also impose a fine. You had asked me at the last talk, who's the fine paid to? My inquiries reveal that it goes to the government. But
Oh, the fine goes to the government.
yeah.
Okay, all this judgment made by MMC, right? Okay, whether it is a reprimand or whether you're striked off, is it made known to the complainer?
Yes, the person that makes the complaint will be informed of the decision. If it's whether or not it's favorable, they'll be informed of the outcome.
Or they will be informed.
Yeah.
Okay.
So, and so that yeah, like I mentioned earlier, they have no power to award monetary compensation. So that is complaints to the medical council. Besides that, doctors may also be called to give their account of what had happened when there's any inquiries by a private hospital or by the Ministry of Health. So under the private healthcare regulations, sometimes when a patient lodges a grievance, there's a duty on the private hospital to investigate that grievance. So as part of the investigation process, they might ask the doctors concerned to give their account of what had happened, and they might get input from the doctors before giving a reply to the patient as regards what had happened. So that's another area which healthcare practitioners may have to be prepared for.
Can you give us some examples of patients who would go to MMC and yet not take a medical legal case against the doctors?
Yeah, okay. One example that comes to mind is it involved a doctor allowing a controlled drug to be taken from out of her pharmacy. This is in a private clinic setting in a small town. So um, there was a complaint lodged against her before the medical council, but as far as I was aware, there's no civil suit brought against her.
Okay, another thing is when you make a complaint to MMC, do you need a lawyer's representation?
No, so you don't need a lawyer's representation. You can choose to hire a lawyer
Mm-hmm.
to represent you, but I would say that it is a lot more important for the healthcare practitioner to have legal representation during the MMC complaint than it is for the complainant.
I
But
see. Okay.
Yeah.
So it is because you don't know whether they're going to take a case against a medical legal case against the doctor or not, right?
Yes. Yes, but having lawyers present at the medical council will still be helpful because the lawyers can cross-examine at the counsel stage when the complainant's witnesses give evidence. The lawyer can cross-examine the complainant's witnesses, so that is a useful role. And also, you can bear in mind that after the Malaysian Medical Council has made its decision, if the practitioner is not happy with the decision, the practitioner can appeal to the High Court. So in the Medical Act, it provides for the practitioner has a right of appeal from decision of the Medical Council to the High Court. If the complainant is not satisfied, let's say the Medical Council dismisses the complaint, then the complainant does not have a right of appeal to the High Court, but the complainant can file what is known as a judicial review proceedings of the Malaysian Medical Council's decision. So at that stage, definitely lawyers will get involved.
Okay, let's go through this again. So when you complain to the Malaysian Medical Council, there will be like a court case. Are you saying?
Okay, they have a very specific procedure. It's not exactly like a court case. So, okay, the procedure has been revamped with the some amendments to the regulations. So basically how it is now is first the complainant will submit a letter of complaint together with the supporting documentation. Then that letter will be looked into by what is known as a preliminary investigation committee. So they will look at the complaint and then they will look at the supporting documentation. What they will do is they will notify the practitioner concerned and they will ask the practitioner for a reply by that practitioner. So the practitioner's response to the complaint in writing will be submitted to the preliminary investigation committee. Then the preliminary investigation committee will look at the complainant's complaint and the documentation and the practitioner's response to the complaint and the documentation, and they will decide whether or not to take further action. So if they are satisfied that, if on the basis of all the documents disclosed, there's no need to take further action, then they can decide not to take any further action and the matter stops there. However, if they think that there's a legitimate complaint that should be looked into, they can forward all of that material to the disciplinary board, and then the process before the disciplinary board will start. So when the disciplinary board convenes, then they will get the complainant to attend with whatever witnesses he has to give.
So also allow witnesses.
At the disciplinary board stage. So if it gets past the preliminary investigation stage.
So now when let's say I complain, I bring my witnesses, who does the cross-examination of those witnesses or the complainant?
So if you complain and you bring witnesses, the practitioner has a right to cross-examine witnesses, but he would be well advised to get his lawyers to do it instead. So that's where it's important for the practitioner to have a lawyer.
Yeah, but do I as a complainant then hold the whole court as in I then cross-examine my own witness and then I cross-examine the doctor himself? Do I do that?
No. So what will happen is the complainant comes with all the witnesses. They will be before the disciplinary board. So there'll be a number of doctors there. So they will then be asked, okay, you want to give your evidence. Okay, please state the evidence that you want to give. And then the doctors on the board might ask questions.
Okay.
And then we go to the next witness and then the next witness.
So it's not exactly like a court case, but if the doctor brings a lawyer, then the lawyer can cross-examine. Then it's again quite favorable for the doctor, isn't it? Because he has a lawyer.
No, the complainant can bring a lawyer if they want, but the things that the complainant's lawyer can do is a lot more limited because interestingly, the regulations as they are now don't give the complainant's lawyer a right to cross-examine.
Oh, that's right.
Defend the practitioner, which is very odd, because normally both sides will have the right.
That's right.
the regulations now are silent. So the complainant can still hire a lawyer, and I guess he can ask for permission to cross-examine. But then if the disciplinary board doesn't allow it because it's not provided for in the regulations, then the lawyer is basically not going to be able to do much there.
Okay, we go on then. It's quite interesting, this complaints to MMC.
Right. So that's the last thing I have to say about complaints to the MMC. Moving on, rest of my talk will be all about medical negligence claims before the courts. So, but one thing which is important, whether it's for medical negligence claims or for complaints, is adequate documentation. So the court will give a lot of weight to the contemporaneous records. So, okay, I've done a lot of these medical negligence cases over the years. So sometimes what will happen is there will be an explanation given by the doctor at the trial, and that explanation is not found anywhere in the records. Now, given not everything is written down, that's natural, but sometimes very important key points which you'd expect to be written down is not written down, and then it can cause problems for the doctor because the judge may wonder, okay, is it not written down because it's made up after the fact, or is it just a case of poor note taking? So whenever anything happens, you'd want to make sure your documentation is as complete as possible. Of course, bearing in mind, you can't write every single thing down, but at the same time, you want to make sure your documentation is as complete as possible so that if there's a dispute later, you can refer back to the contemporaneous records to show that, this is really what happened. This is what we had noted at the time. So if okay, of course, it is not always possible, when you're dealing with an emergency situation, like say resuscitating a child after cesarean section, you're not going to be having the time to write everything on the spot. What you can do is you can write a retrospective entry in the medical records and then note it there that this is a retrospective entry made after the fact, so that everyone knows how that entry was made later, and that's useful. So even if in the moment you can't, as soon as you can, it'll be very useful to make a proper note of everything that has happened. Even if it's an emergency situation, you can do it after the fact. There's certain things which is very, very crucial to document, and I've listed them here on the slides, is if there's refusal to follow advice, refusal to give for the refusal by the patient to give consent to undergo a procedure, and if the patient is insisting on AOR discharge. So in a situation like this, where it is the healthcare practitioner's case that, I advised this, but the patient didn't listen to me, or, I advised the patient to undergo this procedure and she didn't do it, or, we said the patient must be admitted or remain admitted, but they wanted to be discharged to go to another hospital. If there's no documentation, it can be very detrimental to the healthcare practitioner if this ends up in litigation. And there have been cases where this has been the focal issue, because it is recognized practice wherever there's any situations like this, it should be documented. So AOR discharge, normally the private hospital will have a form for this.
That's right.
Refusal to give consent to undergo a procedure, that's usually also a standard form in most private hospitals for this. And refusal to follow advice, even if there's no form per se, it is something that can be noted in the clinical notes of the healthcare practitioner. So this is also, there have been cases where the defendant alleged that the patient did not want to be admitted and sought AOR discharge, but there was no forms and any of that in the medical records, and it was to the detriment of the defendant. And there was a finding against the defendant. The judge was not convinced that the account given by the defendant was accurate because there was no contemporaneous records. So that's the importance of maintaining contemporaneous records. It's in order to show later in court that whatever you're saying is not an afterthought. So there's a few stages for this documentation. One is the contemporaneous records, it's the medical records itself. Later, let's say you get a request from the patient or their lawyers for a medical report or a explanation. Sometimes there'll be things written in the medical report later, which will further elaborate. So sometimes if something is written in the medical report and not in the medical records, there may be a challenge as to whether or not that is really the case, since it's not in the original records, but it comes up in a later report. And what's worse is if something is not in the records, is not in the medical report, and comes up for the first time when the doctor gives evidence at trial, it's going to be problematic for him, because the patient's lawyer is going to say that if this really happened, why is the first time you're mentioning it here at trial and it's not written anywhere before this? So contemporaneous documentation can really save you in a pinch in cases where there can be a dispute around critical issues like this.
Dave, can I ask you, when we speak about medical legal cases, we always think about doctors, but can anyone in the ecosystem, for example, pharmacists, nurses, can they be sued too?
Yeah, there's nothing preventing them from being sued. So in the case of nurses working at private hospitals, it is recognized that because nurses, they're not consultants, they're usually employed by the hospital.
That's
So
right.
the hospital is vicariously liable for their mistakes. So they may not necessarily have to be named as a defendant in the case, but they'll probably have to still appear as a witness if it concerns their negligence. But if a patient or their lawyers want to, they can name the nurses or even pharmacists. But I haven't personally seen a case against a pharmacist, because usually, unless the doctor writes a particular prescription and a different drug is given by the pharmacist, I suppose that's a case where the pharmacist was negligent. I haven't seen any case like that myself, but there is potential for that to happen.
Okay. So anyone can be sued, but because they are under the employment of the hospital, so they probably be covered by the hospital.
Yeah, the hospital would be liable to pay out for any damages in respect of their negligence, and they may or may not be named in the suit. In the case of private hospitals, they don't have to be named in the suit, but in the case of government hospitals, it would be necessary to name the nurses or the pharmacists or whoever else you're going after, because of some legal differences in regard to the cases against the government.
Okay.
So next, I will speak on the duty of candor and good faith. In England, it's recognized that healthcare practitioners, they have a duty to give a proper explanation and a truthful account to patients in respect of anything that has happened. This is especially important when there's adverse outcomes. So several Malaysian cases have recognized that there's this duty of candor and good faith on doctors and healthcare practitioners in Malaysia. And this most often becomes an issue in medical legal cases where there's some element of concealment of either the true cause behind the injury or of something that had happened during a procedure. I can give one example of a case I was involved in where there was a hysterectomy. I believe, yeah, it was a hysterectomy that was being performed, and there was an injury to the ureter during that time, and it was ligated, and there was some bleeding, and there was stitches placed. And basically, the doctor told the patient after the operation that there was no complications. But it so happened that the repair job was not done properly, and so the one of the ureters was completely blocked, and there was there was hydronephrosis, and another surgery had to be done by a urologist to fix the problem. So in that case, after the initial surgery, the obstetrician told the patient there was no complications and dismissed her abdominal pain as a normal post-operative pain. So the patient only found out about there having been complications in the first operation when the urologist did the second operation and told her what he had found. So of course, when that happens, the suspicion index of the patient goes up higher. The likelihood for them to want to take legal action or look into whether they can take legal action is a lot higher. So sometimes adverse thing happening in an operation in and of itself may not necessarily be negligence, but when the doctor is not forthcoming with the patient, it can lead to the patient having this index of suspicion and wanting to see if they want to take action. So even when adverse incidents happen, it's important to give a proper account to the patient. This also can help reduce the risk of the patient being suspicious of not being told the truth and wanting to take legal action later. And
When,
also,
sorry,
uh,
go on
yeah,
first. Yeah, you go on first.
even if, let's say, there was some negligence that had happened. What has happened in several cases is the courts have awarded aggravated damages, which I'll cover later, to on the grounds that after the negligence, the doctor did not tell the patient or gave a phony explanation to the patient. So even when something has gone wrong and it is most likely negligence, it would still be in the doctor's interest to give a proper explanation to the patient in order to avoid the risk of being pegged with aggravated damages against him later in court.
Okay, can I ask you, in this case, was it recorded in the notes that the doctor actually damaged the ureter?
No, in the operation record for the first surgery, it was not recorded.
So it was not even recorded.
Yes, not recorded. So, but during the second surgery, they found a stitch, and the ureter was ligated. So that could only have come from the first surgery. So, but the first surgery reports no complications. So the operation record does not, anyone looking at it will not be able to tell that all of that happened. But it's only on the
But
visual.
the stitch would have been absorbed, right? Must have been quite quickly that she developed this hydronephrosis.
Yeah, it was not a long
thing.
period of time.
Oh my God, this doctor who did this is really, he thought he would get away with it.
Yeah, so needless to say, that case did not go to trial. All the parties settled the case, and that doctor did not tender an expert opinion in his defense. So the inference we draw from that is that he was unable to get an expert willing to defend his care in that case.
Okay. So again, back to being honest.
Yeah. Yeah, but also, and I'll cover this, I'll allude to this later as well, where there's some suspicion of that negligence has happened, it is also important for the healthcare practitioner to notify the insurer of a potential claim. Because depending on how the insurance contract is worded, most of them will require the doctor to inform the insurer as soon as possible. Usually that means as soon as you get a letter from the plaintiff's lawyer, but sometimes it's always better to just be safe and notify them at the earliest opportunity when you know that there's a likelihood of action being taken. That way, the doctor will know that they will be covered. The risk of the insurance company repudiating liability is lesser because they were told straight away.
Oh, I see. Okay. So mainly if there were some complications, okay, some complications are of course not just negligence. It's just like, one of those days kind of for us. If you do too many cases, you will probably tend to have some complications. Some cases are more difficult. Some ureter are placed differently, anatomically different. So even then you have to tell your.
I'm not speaking specifically in the context of this example
Yes,
because
that's right.
that is not, I would say this in very clear-cut cases.
Okay.
Yeah, like for example, okay, can a tumor is available or is visible on a CT scan and something like that, and the radiologist reports it as all clear, and then later you find out, okay, that would be a case where it's very obvious. But in cases where there's just iatrogenic injury during a procedure, we can't be writing to the insurers every time that happens. Of course,
Right.
that would be too
Okay,
much.
okay.
Yeah.
So for example, if let's say I do a cesarean section and I perforated the bowel, that would be something that I would inform the insurance, right?
Yeah, I think that would be that.
Because
It's a question of judgment. It's a question of judgment.
okay.
But that being said, usually the insurance company will calculate it from the date of the letter that is being received from the plaintiff's lawyer. But in cases where it's like very obvious, like I give like you obviously missed the tumor on the CT scan, or you left a scalpel inside, and
Oh
and
my
things
God.
like that.
Okay.
Then you want to let the insurance company know as soon as possible. But when it's like not so clear, then you don't have to worry so
I
much.
think if you have any doubt at all, just inform them. There's no harm.
Yeah, because your premiums and all that will only increase when there's a payout. So notifying them of adverse incidents would not should not harm the practitioner.
Okay, we go on then.
So aggravated damages. So this has been awarded in medical negligence case since this federal court decision in 2018, and this is basically on top of the normal damages that the plaintiff will get. They get something more, which is called aggravated damages, which is usually awarded where the conduct by the defendants has made the plaintiff suffer additional harm. So this conduct by the defendants can be conduct immediately after the negligence, and it can also include conduct during the court case itself,
Oh, I
including conduct
see.
by the lawyers. Yeah. So it's not limited to, so sometimes it also involves the conduct of the case by the lawyers as well. So one example, I'll give examples of aggravating factors here. So it's a non-exhaustive list. So a common ground for aggravated damages now is where it's an obvious case of negligence and there's no admission of liability. So the defendants, even in an obvious case, decide to take the case to trial and put the plaintiff through the stress of going through a contested trial, even in an obvious case. So usually this is in cases where the defendant is unable to get an expert report to defend them, but still insists on going to trial on liability. Or this is also awarded in cases where there's an inquiry by the hospital or the government after the event, and that inquiry has findings essentially of negligence, like that things of breaches of the standard of care. And despite the findings of the inquiry, the defendants decide to not admit liability. In that case, where the patient succeeds, it is open to the judge to say that, hey, you are aware that this case is indefensible. The inquiry report is released well before this case was even started in court, yet no one admitted liability and put the plaintiff through the suffering of a full trial, even though the hospital's own inquiry has revealed all of these shortcomings. So that's something that the judge can consider when deciding whether to not award aggravated damages or not. Or similarly, the judge can think, hey, the defendants can't even get an expert report to defend them, but they are contesting liability. They're increasing the cost that the plaintiff has to incur. So I'm going to punish them with the award bit of aggravated damages for the additional harm that is suffered by the patient because of this conduct. Another common ground is, hiding the truth from the patient, concealment. In some cases, we've seen embellishment of the medical record. So retrospective, entries have been squeezed in between the lines, which were not, these are not contemporaneous, and they're not even marked as retrospective entries. So they've been squeezed in. Essentially, there's embellishing the records to try and support a defense. And where that can be proven and established, that too would be a ground for aggravated damages. Being insulting to the patient when explaining the situation, yep, that also can be a ground for aggravated damages. It's a very non-exhaustive list, but the basic point is you want to manage such situations properly so that later the plaintiff does not have any grounds to seek aggravated damages against the healthcare practitioners. This makes it easier to settle the case also, because when there's no grounds for aggravated damages, the damages are lesser, it might be easier to settle the case. So that's something for healthcare practitioners to bear in mind. It's also something for the lawyers for healthcare practitioners to bear in mind, because you don't want to,
True, very true.
yeah.
Because when I sued the pathologist, now I didn't know anything about aggravated damages, but now I see your list, right? Okay, showing no remorse for the patient suffering, that is very true. The pathologist has showed no remorse. And I think he was, to be fair, he was, how do you call that? Advised wrongly by his own lawyer. So it's very important to get a good lawyer. And then the other thing is the embellishment of the patient's medical record post-negligence. So all the slides for the histopathology of my first surgery that he diagnosed to be what you call that, fibroid, when it was already sarcoma, all went missing. It just conveniently went missing, and somebody had to make new slides from the blog again, you know. So really, honestly, I think that anyway, I understand what's aggravated damages.
Yeah, this is a relatively recent trend. So, like I showed in the previous
Yeah.
slide, since 2018, I think the decision was actually the decision came out, I think, in 2017, and it was reported in 2018. So, in medical negligence cases before that, you probably won't see aggravated damages. But since then, there's a lot of cases where aggravated damages are awarded. And even in this last year, in 2024, you would have seen a mention of aggravated damages in the various online news articles.
There was one case, I think somebody presented where the aggravated damages was more than the actual payout. I can't remember which one. Okay, we
Yeah.
go on. We don't have much time.
Right. Okay. So coming to the tail end of my talk, because I also set some time for questions, is the importance of expert opinions in medical legal litigation. So now, whenever there's a medical negligence case in court, usually if the plaintiff's lawyer knows what they're doing, they will have got expert opinion to support their case. And usually the defense lawyer will also get an expert opinion to see whether they should whether the case is defensible. So, and at some point in time, the court will order all parties to exchange expert reports. So expert evidence in such cases is very important, and it's important to make that the expert be independent and impartial. So the expert's duty is to the court and not to the party that's appointing him or her. And the reason why it's very important for the expert to be independent and impartial is, let me give an example. Let's say the defendant gets a expert opinion that is very defense-sided and is very eager to give the best defense possible for the defendant, to the point where impartiality and independence is not really the priority. What might happen, you have to remember that after the expert report is given, then these experts will come and give evidence in court, and their opinions will be tested and challenged under scrutiny of cross-examination. So if the case is an indefensible case, and the expert is not partial and writes a very defense-minded expert opinion, and that does not stand on the witness stand, it gets the opinion's credibility gets attacked and demolished during cross-examination, then there can be in the grounds of judgment, there can be a adverse finding against the credibility of this particular expert, and that's not good, because grounds of judgment can sometimes be made available to the public and whatnot, and you don't want one's credibility to be tarnished in that way, for being found to be not impartial or not independent. And I just want to give one example of that, which doesn't state the name, but this is what was written about a particular expert who often gives expert opinions. He works for the government and often gives expert opinions defending the government. And you can see here that the judge was very critical of this particular witness's evidence. He says, with due respect to DW4, his evidence does not inspire confidence at all. The distinct impression I get is that he was more concerned with defending the actions of the obstetricians and gynecologists, doctors at HSA, rather than to assist the court in finding the truth. Therefore, where his opinion is at divergence with the opinion of the plaintiff's expert, I prefer the opinion of the latter as being more credible and reliable. They impress me as a witness of truth. So after this judgment came out, the government started using this expert far less, because the expert essentially becomes somewhat unusable, because every time the expert now gives a defensive opinion, any plaintiff's lawyer that is aware of this judgment is going to bring this judgment to the attention of the court and say that, look, you can't trust this expert. He just gives defensive opinions in all cases. So that's why when, let's say, some of the participants here in this talk may be asked to give expert opinions, it is very important to maintain, whoever is instructing you, whether it's the plaintiff's lawyer or the defendant's lawyer, you want to maintain your impartiality and independence so that your credibility does not get damaged like this before the courts. Also, for plaintiffs, experts giving opinions for plaintiffs, it's also important for them to remain impartial and independent, because the same way their evidence will be tested by the cross-examination by the defense lawyers, and something similar can happen to plaintiffs' experts as well. And also, if there's no case in negligence, then it's much better for the patient to find out early from the expert so that they might not necessarily be minded to pursue a claim later and essentially be wasting their time, be wasting the practitioner's time, be wasting the court's time. So independent expert report really helps all parties to, it increases the chances of all parties as, making sure that the cases before the courts are meritorious and that where possible, there can be a settlement, especially where the experts agree with each other.
Are this expert opinion, these experts paid?
Yes, these experts, I mean, I don't know whether in the case of the government, whether the government pays them, but certainly in the private side for plaintiffs and defendants, any expert that you hire it will be paid because they are taking time from their clinic practice to prepare a very detailed expert report. It's not easy work. And they have to do this outside of their clinic hours, usually with a busy practice. So they should be paid both to prepare the report, but also to attend court for their time.
And how easy is it, or how difficult it is to get an expert opinion for the plaintiff?
Certainly, it's much harder to get an opinion for the plaintiff than for defense because the defendant in a particular field will already know the other players and can kind of have a word with with their colleagues to see who is willing to give a expert report. But it's harder for plaintiffs, and in certain fields, it can be particularly difficult. So some fields there might be more people willing to give expert opinions for plaintiffs. One example is, orthopedic consultants are very used to coming to court for giving expert opinions. Usually, it's on quantum for road accident cases, but also for medical legal cases, there's a few that might be willing to give expert opinions. But it depends on the specialty. In the more niche the specialty, the more everyone knows each other, the more unwilling a doctor would. We have found that more unwilling doctors would be to criticize one of their own. And some court cases have even made an observation of that fact. The late Justice Gopal Sriram had made an observation of that fact. But I would say this, that anyone that's approached by a plaintiff's lawyer to give an expert opinion should do so because these expert opinions can really help ensure that so if there's no merits in the case, then you see if the plaintiff is able to get a proper assessment, then the case may not go to court. Of course, the plaintiff, if they are really not satisfied, might get a second opinion, whatnot. But if there's no expert forthcoming, it can result in plaintiffs taking the chance. They're not able to get an expert opinion, limitation is approaching, they will file a claim to take their chances whilst continuing to find an expert. And it can cause problems for doctors as well. Whereas where there's expert reports, it usually can facilitate a settlement. If there's an independent and strong, credible expert report, and that is disclosed to the other side, let's say the plaintiff discloses it to the defense side, that expert report can help get the case settled. So, in a sense, it can also help the other healthcare practitioners in that having good expert reports can assist in early settlement of cases. So that's one way I would invite healthcare practitioners to look at it if they might be reluctant when a plaintiff's lawyer approaches them for an expert opinion.
Do all indemnity insurance cover the doctors if the cases don't go to court and is settled out of court?
So most insurance does cover out-of-court settlements as well, but of course, you must get the insurance company involved in all these decisions. So you can't reach a settlement and then tell the insurance and expect them to pay, of course. But if the insurance is notified early, normally what they will do is they will hire lawyers to take care of the problem and get involved at the early stage, whether or not a court case has been filed yet. And sometimes, if they're so minded, they will instruct those lawyers to investigate the possibility of a settlement even before there's a court case.
Okay, can I ask? Okay, obviously, if the case is prolonged and goes to court, then the defendant's lawyer, the defendant is covered by insurance anyway, the lawyer will be able to make more money if the court case is dragged, right?
That depends on the billing structure for the defense lawyer. But yeah, that is certainly a possibility.
So the defendant may be advised wrongly so that the lawyer can actually drag the case. Is that very possible?
Okay, that's possible, but I'll add to that. You see,
Uh-huh.
so a lot of these insurance companies, so not all, so it depends. Some of these insurance companies, like I give you an example. Okay, maybe let's not name names, but some of them have their own team or their own
Panel.
medical legal team that's looking at it. So the lawyers
Or the
will.
team within the insurance itself?
Yeah, this is if it's a specialist organization only for medical indemnity
Okay.
insurance, then they might have their own doctors working on their team. So when the lawyer gets an expert opinion and advises them whether or not to settle, they might have their own people looking at it and making an assessment for themselves as to whether, they are in agreement with the advice by the lawyer. But I can also say that there are some insurance indemnity providers which, they provide all sorts of indemnity. They don't have a specific team for this, in which case they are a lot more reliant on their lawyers for advice, in which case I suppose there's danger. But from the lawyer's perspective as well, if it's not nice to have a obviously indefensible case and be taking it to trial. It's not necessarily very pleasant, and so if they have a number of cases that they're dealing with, they probably would want to focus their attention on the cases where there's a more meritorious defense. But I can't speak for, I'm
Yeah.
not on any panel, so that's really up to the lawyers themselves as to how they conduct themselves.
Okay. Your slide, we go on?
Yeah, so this is my last slide before the question and answer. So this is professional indemnity. So I'm sure most of you would know that it's a requirement under the law. So you must purchase professional indemnity. Interestingly, the law does not state specifically how much your coverage should be. It just states that you should have indemnity, but it doesn't specify, okay, for this particular kind of consultant, it must be this much. For this kind of practitioner, it must be this much. For a GP, it must be this much. There's no specifications as to that. So as to how much coverage you get, that is up to the healthcare practitioner, but you should make sure that your coverage matches the risk involved in the kind of cases that you do. So for example, if one is an anesthetist or an obstetrician and gynecologist or a neurosurgeon, in all of these areas there is, or even a pediatrician, in all of these areas that there's a risk that you might be dealing with adverse incidents which result in brain damage. So usually where an incident results in brain damage, the quantum is, and the patient survives, the quantum is in the millions. Those are the kind of cases that you would have seen in the news reports over this year. So where the quantum is in the millions, you want to make sure that you have enough coverage. So you don't, so there are different packages for, 1 million, 3 million, 5 million. So if you're dealing with high risk situations, birth of babies or anesthesia, neurology and pediatrics, you probably want to go for the higher end cover because the quantum in your case can amount to millions. So you don't want to risk it by having limited cover. Because let's say the doctor only gets 1 million cover or 3 million cover, and say, like in some of the recent articles, the judgment is 5 million plus, then the risk that the healthcare practitioner takes is that if once the plaintiff gets the maximum amount from insurance, the balance, they might go after the practitioner themselves. They might put enforcement proceedings against the practitioner. It can eat into their savings and their properties and whatnot. So that's something that it's a very big risk if you are underinsured. So whilst the premiums can be expensive, you got to weigh that against the risk of a very large judgment sum in the case of an adverse incident and a finding of negligence. But of course, if one is a GP that does not perform any risky procedures and all that, then it may not make as much sense to get that high coverage, and the premiums are usually adjusted accordingly. So you want to see what is your risk portfolio like to make sure that you have sufficient cover. And also, it would be good to bear in mind, see, cases that start, let's say something happens in 2024 or something, like let's say something happens in 2024 and the case is only brought in 2027. The trends of damages for medical legal cases is going on an upward trend now. So whilst now the damages might be at, say, for a particular type of case, it might be 4 or 5 million, you don't know whether it'll be 4 or 5 million two,
In
3 years
7 years
down the
time,
line
yeah.
when the suit is brought. So if you might otherwise be minded, say, I think my maximum a claim against me can be is for 3 million. You might want to get 4 or 5 million instead, because you don't know when the case will be brought and what the trends will be then. So very important to have adequate cover. And as soon as you get the letter from the lawyer, make sure you notify your insurer so that they have no grounds to escape having to indemnify you. But so far, I've not come across a case where, to my knowledge, where the insurer has refused to do so because of not being informed. But I assume that most doctors would be informing them straight away, or close to straight away anyway.
Okay. I wanted to ask something, but I've forgotten now. But so we'll just take questions.
Sure.
Can you stop share for a while, please?
Yeah.
Thanks. Let me just share this first, yeah. Okay. So can you just see the chat and then read while I do this? I'm so sorry. Yeah. Okay. So basically, I just want to say that today's webinar is actually sponsored by Dr. Shield. And if you buy your indemnity from Dr. Shield, use the promo code for 5% discount. And it's very easy. You can get your quotation from just going to the website. We will take some questions. And I think the first question is Dr. Kim from Doquity asks, does the law make any effort to differentiate between medical accident, meaning recognized complication from any surgery or procedure, from true negligence? When a surgeon operated on a patient while the patient was under influence of alcohol. But negligence can also happen in a sober doctor, okay? From ignorance, from couldn't care less, from poor training, from being gung-ho, right or not?
Yes, I've actually not seen a case where the doctor was drunk during the procedure. I think, easily be a case that will be settled very quickly. But the law does draw a distinction between adverse outcomes and negligence. Not every adverse outcome is negligence. If every adverse outcome is negligence, then that's it, habis for all the doctors. So the patient has to prove that the doctor had breached the standard of care and that breach had resulted in damage. So this is usually determined by expert evidence. So the patient would usually have to bring an expert in most cases to give his opinion as to whether there are any breaches in the standard of care. That means where the doctor has gone outside of ordinary practice. Now, the healthcare practitioner that's being sued will usually also get an expert opinion. And sometimes the expert opinion from the doctor will say that, the doctor had acted within ordinary practice. So there can be differences of opinion, but as long as a reasonable body of opinion supports what the healthcare practitioner had done, that would amount to a proper defense for the healthcare practitioner. Of course, the reasonableness of that body of opinion is something that the court can look into. But yes, it's not just adverse incidents. The burden is actually quite high on the plaintiff to establish, because the plaintiff has to call expert opinions that will support his case to show that the doctor had breached the duty of care. And I can tell you, it's not usually, if there's no such, it's quite difficult to invent a breach where none exists. So that there is a distinction, and that's something that the court will take into account and determine based on the expert evidence and all of the facts of the case.
But it's also important to, I think, stress that any complications from any surgery should at least be explained to the patients during when you're taking consent, and also the documentation of it all, right?
Yes, yeah. So there's certain risks where if it's a very, very small risk, then it may be acceptable for the doctor to not disclose it to the patient. But then even for small risk, if it's a small risk, but the doctor knows that because of the personal circumstances of the patient that they'll want to be they'll want to know of the risk. So for example, if there's a small risk of vocal cord injury, it's a very small risk, but the patient is an opera singer, then the doctor knows that, then that risk would arguably have to be disclosed. So that goes into a body of cases regarding what sort of risks have to be disclosed or not. But in the absence of, special circumstances, you'd want to disclose any material risks to the patients to safeguard yourself.
Okay. Dr. Kati Ravan asked, Dave, doctor write contemporary record after they are sued. I don't understand that. Is that a statement or a question? How can the court determine the records are written at the time of incident and not doctored after the legal notice?
Okay, that's a great question. So I can give examples of how this has been determined in the past. So patients' lawyers will normally ask for copies of the medical records from the hospital. They will get copies of the medical records from the hospital. Later, they may file a suit against the doctor concerned. And then what the doctor might do is he might write in some entries at that point after he knows about the suit, not having realized or not knowing that the patient has already got copies of the medical records from the hospital. Then later, the doctor produces the medical records, but with some additional entries written in after the fact. The patient having got copies of the medical records before those additional entries were there, if the patient's lawyer is doing his job correctly, he will notice, hey, this is written here, but not there, and it's supposed to be the same thing. So that's one way where the doctor can be caught in having added things after the fact. Other ways is where you see that the doctor's handwriting is one way all across the records, and then suddenly for the most critical point, it's in the neatest handwriting ever, and it's in squeezed line. Yeah, everywhere else it's they skip one line, and then here for the most critical point, it's super neat. It's a squeeze line. So
Okay.
yeah.
Okay, so I want to ask you, these days a lot of it are paperless. So when you request for medical records, what happens?
So if it's electronic, like a typewritten records, electronic medical record system, then we will usually get the electronic medical records. But in cases of catching and entries that are added after the fact, it can be more difficult. But usually, if things have been edited on the electronic medical record, there might be something at the bottom which says edited on this date. But the problem is, it might say edited on this date, but it won't show what has been edited, what has been inserted or not.
Yeah.
So in electronic medical records, it can be more difficult to catch contemporaneous records that are inserted after the fact. So what the patient might want to do is sometimes, if you're very, very worried about a doctor doing this, you might want to perhaps just get the records from the hospital first before even writing to the doctor. But then, even when you write a request to the hospital, if it's a small enough hospital, the doctor might get to know about it anyway. So, yeah.
No, because you see, in medical records, there is electronic, okay, there is an edit button, and in some cases, they will say save draft or save. In my case, everything is save draft, okay, not because that I'm worried that I have to, okay, my documentation is very good, but there are times where I save draft because I scared that the computer crash or whatever, or sometimes that I always save draft, I never save, okay? So I think you can actually request them to see the edit history, just like in Facebook, there is an edit history. So I think the lawyers can ask for that. Okay.
Right.
Dr. Chan KH asks, if during a surgery and the surgeon did a procedure which is not relevant, okay, but the patient's verbal agree but it's not documented in black and white, can we nurses, the assistant in the case, document it in our intra-operation document for our safeguard purposes? Oh, okay. I get what the nurse mean. Do you get what the nurse mean?
Yeah, the short answer is yes, of course. Anything that actually happens, you can document it for
Yes.
safeguarding purposes. It doesn't have to necessarily be in So yeah, there's a consent form, but on top of the consent form, there's also the nursing notes and all of that. So as long as it's recorded somewhere contemporaneous, that will always be helpful for the courts.
Okay, this is a very important question and it's a very important point. Okay, now unfortunately, a lot of doctors are very creative, okay, during surgery. So for example, they do this, then they do a few other things while doing it, either appendicectomy or cholecystectomy or mentectomy or whatever, so that they can put it into the insurance as, how you call that, billing. Okay, so, but it may not be documented before that. Okay, and then they may give an excuse after that. Yeah. So yes, as nurses, I think it's very important for that. And also it will protect the hospital when you do that. Means you document it as nurses. I think it's very important. Okay, from Dr. Awatif asks, how far the price differs from indemnity, either on time-based or case-based? I don't know the answer. I don't know.
I also don't know the answer.
I think, is there anyone from Dr. Shu here who can answer that? Okay, what is the minimum fees or charge for a patient to pursue a medical legal fee case?
Yeah, okay. You see, it really depends on the lawyer that they hire, but generally speaking, it is not cheap because these kind of cases are quite complex, involve specialized knowledge, and they are usually more complex than the average personal injury case. And besides legal fees, on top of that, you have to bear in mind that the patient will have to pay for the expert report. And sometimes just to get the medical records, if it's very voluminous or several months admission, the hospital too will charge processing fees to just release copies of the medical records. So all of that will add up. Even it's quite an expensive affair. It's not cheap. That I can tell you for sure.
Okay, so when the patient actually take a case up against the doctor or a hospital, do they pay an upfront or they pay when they get the
Yeah, it really depends on the individual lawyer. So a lawyer can choose to charge the majority of his fees at the conclusion of the case, which is probably the time the patient is in the best position to be able to afford to pay fees. Some lawyers may not be comfortable with that. They might charge incrementally, which means the burden on the patient is higher because they'll have to pay for the expert report fee as well as the lawyer's fee, at least part of it upfront. So yeah, I know it varies. It depends on the lawyers that you get. There are some that charge upfront. There's some that charge the majority of the fee at the conclusion of the case. It really depends. There is some variation in the market.
Can I ask, is it legal for lawyers to do on a success basis?
Okay, what is known as contingency fees is currently illegal in Malaysia. But what's important is to realize what is illegal. So what is illegal is if it's a fixed percentage and if there's no win, no fee. So that means that the lawyer says that, you only have to pay me if I win, and you have to pay me X% of whatever you get, then that is a typical classic contingency fee arrangement. But if you're going to pay something, even if there's a loss, and if the fees paid is not fixed to a fixed percentage, let's say it's a range instead, then that would not fall foul. So you can see arrangements which are similar to that but are legal. And then you might see some people that I think this it's an open secret that in road accident cases in certain circles there's fixed percentage and no win no fee and things like that, but that would not be legal.
But it is not easy for a lot of patients to come up with medical legal fees. It's almost impossible. Some of them are really poor.
Yeah, I'll give an example. Like, let's say there's a delayed cesarean section at a government hospital and results in cerebral, a child having cerebral palsy. You know, the family is already going to be so strained looking after the child
Yeah.
that even to pay, forget legal fees, even to pay for an expert might be very difficult for them. So, you know, in those cases, the existence of more flexible fee arrangements where the majority of the fees is not upfront is probably going to be more workable for them.
Yeah. Okay, Dr. Rachel asks, is it legal for a GP to reject to attend to a patient who's brought into the clinic unconscious? Okay, can I extend to that? Is it legal for any of the doctors to reject any patients at all for any reason?
I think in a private setting, you know, the hospital does have you know they can say, you know, they can charge the fees and all that, and if the patient is not happy with all of that, they can technically reject treatment. Let's say if the insurance card you know is not covering it and the patient is not able to pay, they can reject treatment. But
The hospital can reject, but can the doctor reject?
a doctor, say, employed at a
No, because for example, Dr. Rachel said the patient is brought into the clinic unconscious. I do not know why would you not accept the patient? An unconscious patient for me is easier than a patient who is difficult.
Yeah, actually, that's I've not been asked that question before, so I'd have to look into that. Actually, I know that hospitals can reject patients if the payment is not met, but then again, you know,
No,
I'm
no,
not
no.
sure.
Yeah, that one is not that one is very common. But for us to reject patients is, I don't think. I mean, I've like, okay, if you don't really get, you know, like me, maybe you can see another doctor very, very seldom, but I cannot like, okay, I do not want to see you anymore. Only once.
Right. I'll have to look into that, and also it'll be interesting if, let's say, it's a GP and you know the GP's practice and the
No,
GP
I
doesn't
don't
want
know
to.
why, Dr. Rachel, why are you worried about attending to a patient that is unconscious? It is very important. It's your duty of care. If the patient is even more ill, it's an emergency, you can't reject. If a patient is very difficult for no reason at all, aggressive, then maybe I would think so. Okay, Dr. Jagannath asked, what age limit for a GP managing basic? What's the age limit? Oh, I think, I'm not sure. I mean, as far as age limit, GP, okay. Oh, what he's asking is there an age limit that the indemnity insurance will cover? That I'm not
You
sure.
mean until the GP reaches a certain age?
Yeah, that's right.
Uh,
But
Not to my knowledge. I think, as far as I'm aware, insurance companies are happy for doctors to continue paying premiums and for them to cover. Because especially as the doctor's practice winds down, that's actually very good for the insurance company because the doctor is still paying premiums, and as his practice winds down, he's probably doing less invasive stuff and risky
yeah,
stuff.
true, true.
So I don't see any reason for why they would do that, but I have not seen all insurance policies, so there might be some that have some sort of age
Okay,
limit.
Dr. Rayleigh asked, why is it doctor have seen patients in hospital mostly don't want to testify in court if it's a medical legal case?
I can answer that. So
I
very
don't
quickly,
answer that.
yeah. So let's say, okay, it's hospital A. Okay, there's hospital A, and then the doctor is being sued, and someone who's not a defendant is being subpoenaed by the plaintiff to give evidence. So the reason why probably they'll be reluctant to give evidence in court is they know that, okay, the plaintiff's lawyer is subpoenaing them for a reason, and probably it's to establish the case against their colleague who they see every day or every few days in the same hospital and work together with. So uh, obviously, that would be a bit of an awkward situation, but at the end of the day, if they are subpoenaed to attend court, they just have to attend court and be truthful about what had happened, because their records will be there. They'll have either their medical report or the contemporaneous medical records, and they really can't escape if there's a subpoena. So of course, what they can do is they can tell their colleague in the hospital, look, I got no choice. Plaintiff's lawyer served a subpoena on me. I can't ignore the subpoena, so I got to go. They can do that, but that is probably one of the reasons why they are reluctant to testify in court. There may be other reasons as well. Of course, testifying in court is not necessarily always the most pleasant experience.
Yes.
So that in and of itself might be a reason why people in general, not just doctors, may not like to testify in court. And there can be other reasons.
Yeah. I think one is that if I have a colleague I would definitely do not want to go and testify against my colleague unless I'm subpoena. That's one. Two is I have actually sued a doctor before, and as a plaintiff, it was extremely stressful. I mean, it's very, very stressful. Even when I think that there is definitely cannot not win this case, when the person is being cross-examined by my lawyer, I go, okay, I'm going to win, I'm going to win. When the witness is being cross-examined by the defendant's lawyer, then I'm like, okay, I'm going to lose, It ding dong, and I tell you, it is extremely stressful. And I'm a doctor. I'm quite strong to say I'm quite strong. Can you imagine if you are uneducated, your child has now brain damage, and you don't know the law, you don't know much, it is a very difficult position for anyone, for the doctors, for the plaintiff, for everyone. It's not a pleasant thing, not something that I would want to go through again as a doctor or as a patient. Yeah.
Yes, indeed. Yeah. This is why the best result, as far as the lawyers are concerned, actually, as far as everyone is concerned, even the court and the parties, is if the cases can be settled with, with good expert opinions. If good expert opinions are provided, the chances of settlement are greater, and that can be good for all parties concerned.
Yeah, I think that there's no shame in admitting if you are wrong. Yeah. I think that's that. And yeah, it was a very good session. It was not hacked by a pawn this time around. And I think we'll definitely invite you more next year, because this year I think we are almost all done, another 2 months to go and more holidays. So next week we don't have any webinar because it was meant to be forensic psychiatry, but Dr. Isabel has a viva, so she can't do it. And I don't know whether we missed the question or not. Okay, I think we have done. Anyway, thank you everybody for joining us. Thank you very much, Dev. Catch up one of these days.